you're here, if you haven't noticed, to listen to us and participate in a conversation about collaboration and conflict among medical, legal, and law enforcement professionals, and how we can achieve equitable care for our patients in the emergency department. I'm going to introduce our panel. My name is Andrea Wu. I am faculty at Harbor UCLA, and I am the Vice Chair and Director of Clinical Operations. All of us, I think, are from different backgrounds. We have here some very amazing people from law enforcement background, from a legal background, and a few physicians of varied geographic location to kind of give us an idea of sort of the variety of ways things are approached across the country. So first, I would like to go to Lieutenant Sydney Connor. She's a sheriff that is now retired from LA County. If you give us like a little introduction about yourself.
Certainly. Good morning, you three. Hope you had a fabulous night in New Orleans. As I said, my name is Sydney Connor. I am retired from LA County Sheriff's. Worked there for 30 years, multiple assignments. One of the last assignments that I had the good fortune to work was when our department took over security, safety responsibilities for LA County healthcare system, which is the second largest system in the nation. And when we did that, primarily my background was in training and tactics. And when I was part of the merging team as a lieutenant, we had zero understanding of what healthcare, what it's like inside a hospital. And it was very eye-opening for us to first understand the environment, how dynamic it is, particularly in the ED, and observing so many similarities between the ER and what law enforcement experiences. One of the biggest observations, aside from a lot of safety issues, but you're adrenaline junkies just like us. But we were there to learn and support and make it safer, to build a better relationship between all law enforcement agencies and healthcare, because within law enforcement we have a lot of organizational arrogance when we come in and we think we own everything and that everybody should follow our rules, and that's not the case always. So myself and my peer Greg here, part of what our roles and responsibilities that we developed was not only liaisoning with outside agencies, but developing policy and procedures and training opportunities to ensure safety and a better environment for you to work in without us, law enforcement, getting in the way. Thank you.
Thank you. We'll go next to, I was going to actually do Greg first, so that's okay, just since they're, thank you.
Hi, my name is Greg Evans. I'm currently a lieutenant with the LA County Sheriff's Department. I'm assigned at Malibu Lost Hills Sheriff Station. Prior to that, though, I spent 10 years as the Sheriff's Department liaison with Harbor UCLA Hospital. I'm not necessarily, there's always the disconnect between law enforcement and people in the ED when we come in. Some people don't think that law enforcement should be there. Some people think that they should be there. I'm here today just to talk about the fact that regardless of whether we think we should be there, we shouldn't be there, we're there. So we need to do what we can to make sure that we're able to work together so everybody accomplishes the goal that they want. I think that we probably don't have a lot of time, so I'm going to move on back to you.
Hi, good morning. Welcome. I'm Debbie Korzenik, and I'm one of the in-house attorneys at Mount Sinai Health System. We're the second largest non-governmental employer in New York State, so we're pretty huge. And I've been in-house for years in the healthcare system and was a generalist, and now my focus is patient care. So I get the calls during the day and in the middle of the night from ED and other places with these kind of complicated cases. I'll just end with quoting my cab driver this morning on the way over here. He asked me what I was doing here, what I was talking about, and he said, "Wow, that's pretty cool." He said, "It must be very hard to get everybody on the same page. He said, good luck with that.
I have to say, though, in meeting these lovely individuals, that I realize that not all of us are from the same specialty, and even within our same sort of discipline, we may not be of one mind, right? But I will say that like coming together as a group is the first step in trying to figure out how to navigate all of this, and so I really appreciate you guys all coming. I do want to introduce the three physicians quickly. So first, we have Dr. Julian Mcgreevy. He is the Vice Chair and Vice President of Clinical Operations at the Department of Emergency Medicine at Mount Sinai Health System. Also has a Master in Bioethics and is the Ethics Committee President. Dr. Quincy Moore is an Assistant Professor, also in the Department of Emergency Medicine at University of Chicago. And then last but not least is Dr. Natasha Thomas, who is the Assistant Medical Director and the Director of our Trauma Recovery Center at Harbor UCLA. So you can see we have quite the geographic representation and sort of multidisciplinary. This didactic is Ethics Committee sponsored as well, so there will be a focus on sort of the ethical issues at play. So I want to give a little bit of an introduction of why we think getting us in the same room is important. You know, I think first and foremost, for the physician, our goal is always patient first, patient's medical care first, and then patient privacy, especially as we interact with so many different people in, I don't know why the slides want to keep moving, the sort of different people that we interact with. And in particular, you know, I think that patients are vulnerable when they come to the ED. Oftentimes, these patients are coming in as trauma patients, but they not be able to have the ability to give consent for their own care or give consent to have conversations with other people. And it may be hard for them to differentiate between hospital staff and law enforcement staff. You know, in the whirlwind of all the people descending on them in the trauma bay, it may be hard to tell who's who. And then there's this potential issue of the patient feeling implicit to comply, that their care is tied to them cooperating to whoever is approaching them, right? And so if it's difficult to tell who's who, they might be afraid to, be truthful about what happened, or they may withhold information, or may not even want to really participate in their care. And so I think there are a lot of issues that make it difficult for the patient and for the physician. I do want to highlight the one perspective that's missing from our table, right, is we don't have the patient here. We don't have an advocacy group that's representing what the patient is experiencing. So I do think that is an opportunity for us moving forward to get that voice on the table with us. The other thing that is important is to acknowledge that law enforcement has a job too, right? Their role is to make sure that the public is safe, that everyone is safe. And some of their investigations, similar to our work, might be time sensitive and understanding what those situations might be. And then because of sort of our potential varied priorities, there's some inherent conflict that presents when we interact with each other. And I think that, maybe those minority of cases where we get into some tension with law enforcement, those tend to stay with us and potentially, perpetuate in our future interactions with law enforcement. And I think it's important to try, at least ahead of time, to understand what those maybe different priorities are and why it is the way it is. And we're all trying to help in our own way, but in different approaches. So how do we navigate all of this, right? How do we communicate in a way to another specialty, to another type of role that isn't an expert in our area? I'm definitely not an expert in their area, right? So how do we figure this out? And so I think the thing that we need to focus on is maintaining privacy, making sure that patient care is the priority and not interrupted. I think what complicates things, which is why I'm really proud to have Debbie here as well, is that law enforcement in the ED, there's a core precedence to say that because they are allowed in through the emergency department, that it's considered a public space, right? And so policing in a public space may be potentially a whole nother ballgame of how things are interacting with us in the ED. So there's legal ramifications for the patient, clinical staff, the hospital. It can affect the patient's criminal justice proceedings and how we deliver trauma care to patients. And there are a lot of ethical principles that come into this as well, right? We have a duty to patient privacy and the duty of the patients first, but we also have a duty to society and the public good. And we want to ensure that health equity is something that the patient can receive while seeking care, that they feel safe and comfortable coming to the ED in whatever emergency it is that they have. And so that we are not denying, sort of by accident in some way, denying access to patients' care or giving them barriers to experiencing that care. So how do we navigate this, operationalize it in a way that addresses all these complexities of the clinical component, the ethical component, and the legal component, and provide a way of consistency in the approach. And so I'm hoping that we can help provide you with a little bit of information and bring that back home to your emergency departments. So things go wrong, and when they go wrong, they tend to get in the news. Unfortunately, there have been cases where patients that are seeking care are shot by law enforcement, potentially on hospital grounds, and that's happened in multiple places. There's also the incident where the nurse didn't want to draw a blood alcohol level on a patient that came in, but that couldn't give consent. So I think that there's a lot of potential for conflict here, but I think if we can get ahead of it and talk about it, that it would serve us all well, and our patients particularly. So I want to put this here for a second. If you want to pull this up quickly on your phone, it's going to be our way to enter questions in, and then I'll bring them to the panelists. So polleverywhere.com, pollev.com/Andrea Wu, oh my goodness, and 549. These will be at the footer of each slide, so I'm going to present the first case. So the first case is a 30-year-old male brought in by EMS after a high-speed motor vehicle accident. A typical day for us in the ED. He is restrained, the airbag's deployed, and there's front-end impact, and he requires extrication. He's hypotensive, tachycardic, he has a deformed femur, open ankle fractures, he's altered with GCS-14, repetitive questioning, he's agitated wearing a spit mask, our favorite, right? And then in addition to this, the patient is cuffed by the police that are bringing him to the stretcher. They say they found alcohol and amphetamines in the car, and there was a fatality at the scene. And the ED staff are trying to ask the officers to uncuff the patient so they can start the medical care and to have them wait outside. The officers remain in the room, they're trying to ask staff questions, and they're requesting a blood draw for intoxication. And then, as this is all happening, the officers attempt to proceed to follow the patient to the CT scanner. So, several things here that I want to touch upon. And the first question I'd like to pose to Quincy, Cindy, and Debbie is, the police want to know the patient's injuries and clinical status. What can we tell them? And then can you also explain to us a little bit what an exigent circumstance is?
Thanks. Can everybody hear me? Okay, so I think first of all, as ED providers, we can all tell this patient is not doing well. So in terms of just prioritizing the health of the patient, clearing any non-clinical personnel from the clinical space, and prioritizing resuscitating this patient as we would anybody else should really be the priority. In terms of actual information sharing, when that issue presents itself, there's a handful of different roles that a patient might be playing in an ongoing investigation. So whether that's suspect, witness, fugitive, or victim in a crime, and there's some kind of nuances to what we are allowed to share depending on what their specific role is. But regardless of their role, patients' privacy is protected by HIPAA. So there's some legal protection there, and then there's also, ASAP doesn't have a ton of policy around this issue, but they do have a policy statement that's related to law enforcement information gathering in the ED that states, except when legally required, information about a patient should not be released without permission. So these protections extend to all different forms of information sharing. So it's important to think about, both individual conversations that you might have with law enforcement, but also any eavesdropping, any viewing of medical records, and also the rest of your team, right? So oftentimes we're in there initially, maybe we scurry back to our computer to put in some orders and write a note, but our nurses and our techs and whoever else is still in the room. So, I think being in that leadership role in the emergency department, it's important that we, think about our patients' privacy as it extends to the entire clinical team. So in terms of actual information sharing, so the most common scenarios are going to be either a suspect in a crime or a victim in a crime. In terms of the victim scenario, if a patient is able to consent, then law enforcement, I'm just going to talk. You guys hear me okay? So in terms of a victim in a crime, so if a patient is able to consent, law enforcement has to get consent from the patient in order to get any information. If they're
Okay, you stole my thunder. It's pretty simple. Breaking it down, we're in the ED department because, as Quincy said, it's either a suspect, a victim, a witness, and potentially you could have somebody who is absconding, meaning they're wanted in a crime. But in this particular scenario, because the suspect is brought in and he's handcuffed, one thing that sometimes we in law enforcement fail to provide is common sense. And as my mom would say, common sense is not common practice. You have a suspect that's handcuffed to a gurney and is clearly not going anywhere due to their physical injuries. And although this suspect is our responsibility because they are in custody, we are responsible for them in the sense of they're in custody. However, common sense is to not interfere with their primarily their safety and their care. So in this particular case, we're asked to unhandcuff them. We're going to do that. We should do that. But if I can front load a little bit here is, and it's very difficult to have a pre-established relationship, if it's possible at your hospital, with your local law enforcement agencies. That's really extremely helpful to have that pre-established relationship, so that talking about these various scenarios that you're front-loaded, so that when they occur, that there's already somewhat of an understanding. Because as Greg will tell you, for us, when we first came into working in the hospitals and observing multiple agencies, 20 plus different agencies coming into one hospital, the response from different agencies was not necessarily in sync with what we observed they should be doing to support doctors, healthcare providers, to ensure the proper care for patients.
Thank you. So you both stole my thunder. Because no, it's great because you guys covered the basics of the law. But I just want to emphasize that the HIPAA law applies to all of us, but state laws vary enormously in this area, and it's really important that you know your state law and that everyone in your department know it. And then to Cindy's point about getting to know your precinct and the officers there and making sure everyone's on the same page, I can't emphasize enough how important that is to establish those relationships. A couple of years ago, there was a meeting in New York, Greater New York Hospital Association pulled together for this purpose senior leadership in New York police and in-house counsel from many of the major hospitals. And it was shocking how everybody had a different view of their rights, and the hospitals also had very different approaches. So it's very important to also have policies in this area and to make sure that your staff are familiar with them. Another point I just want to make is that the HIPAA laws, obviously, if you have documents compelling sharing of evidence, that's easy enough to follow, although you can challenge them if you don't think they're appropriate. Most of the time we don't do that, but it is an option. But there are a lot of things that are discretionary that you have a right to say, like this provision exception in HIPAA to sharing information about a suspect or about a victim. For example, in the case of a victim, you are making the judgment whether this is, whether law enforcement's acting properly and whether sharing of information, even though it's a limited demographic information, is in the patient's best interest. So there is discretion there on the part of staff. And that's it.
Debbie, I was hoping you could comment a little bit on what an exigent circumstance
So I
is.
think yes, I will, but I think that's more appropriate when we get to the blood draw.
Yeah,
question.
okay, well, let's get there.
Yeah, so I think the one last thing is that in this scenario, the officers are not listening. They were asked to step out
Right.
of the room, and they're not, and they're following the patient to the scanner. That's not okay. They don't have an unbridled right to move around the ED in private places, and so It's okay to let them, if it's a suspect in particular, they want to have visual contact, but they don't necessarily need to be in earshot of what's going on. So.
Right. I think that's a key component, too, in how law enforcement potentially approaches that particular patient, right? Depending on sort of what state they are, if they're a suspect, if they're in custody, sort of the approach that they take is going to be very different. But I think the universal theme, despite any of those sort of qualities of what the patient is sort of going through, is that we really need to respect the patient's privacy. And it is okay to have law enforcement step outside, and it is okay to have them out of earshot. Right. It may be that if someone's in custody, they need visual eyes, depending on the circumstance, but it is important. That is something that we feel we can ask of them. Okay, so I'm going to move to the next sort of, oh, of course.
So if the CT scanner is down the hall or in the corner, the police officers can go there to maintain visual if the patient's in custody. And the officers go just to maintain visual. They're in the control room maintaining visual. Is that exactly?
Yeah, I mean, these are difficult judgment calls, and it depends on, you know, what, if it's a scan or what procedure you're doing. There may be times where they can't be in visual contact. It depends on the circumstance, but the point is you can try to allow for it when it's appropriate. It really depends. It's so circumstantial.
There's a lot of common sense that needs to be applied into it. I have an in-custody DUI, and he's going to CT scanner. I know his name. I have all the identifiers. He's he's clearly in need of treatment. He's not going anywhere. I don't want to interfere with the care that he is required, and I don't want to dominate the room and interfere with doctor's care for the patient.
And it should be said, since it hasn't been said yet, a prisoner in custody actually has a constitutional right to receive care. And that's something that law enforcement and the jail and the prison side, it's really important to recognize. And that's something that in this situation is one of those, it's part of that balance, is there actually is an obligation on the part of law enforcement, but they have to see it in the balance of maintaining custody.
Correct.
And the other part is agencies often have very specific rules about what degree of control they have. So my hospital deals with 27 agencies, and some require that you have 2 officers with, that's what they're calling, with the patient at all times.
Where is your hospital?
In Atlanta. And that becomes a very challenging, what exactly does that with me? And certainly this patient being agitated, perhaps actually fighting us, there's a whole nother wrinkle of our safety, which is, do the people in the room know what to do to safely without
Right.
causing additional harm?
So we're going to touch on that in a little bit too. Yeah. So, I mean, the other thing that, Debbie brought up is sort of this issue of forensic evidence around blood draw requests, right? And I want to see sort of what you guys think of when is this allowed, how should it be done, how does it vary potentially by the location you are working in, which state you're in. And so, if Julian and Debbie, you can help us understand sort of the legal and ethical issues behind this.
Yeah, thanks, Andrea. So, the blood draw case is a good paradigm ethics case, I think, to think through in advance, because, you can solve a lot of other problems having thought through this one. So, I think as others have articulated, the primary principles really are privacy and the well-being of the patient. That's got to be number one in all cases. But, there are some other considerations, right? One is the health equity piece, right? The biggest concern would be patients who are deterred from seeking care or providing the information we need to care for them because they're worried about law enforcement. And then on the other side, there is a duty to public safety, right? I think we know the impact of drunk driving, right? And so I don't think we can ignore that. Thinking about the people that are in the room with us, many might have, views about our obligation to society at large in the case of, drunk driving. So, I think the blood draw case really breaks down into sort of 3 versions. One is the patient consents and says, yes, that's okay, you can do a blood draw. It's relatively straightforward, like other consent issues, with the caveat that Andrea mentioned earlier, which is that the patient may not be able to tell the difference between law enforcement and us. And if they think that saying yes to the blood draw is important for their care. In other words, we won't care for them if they don't say yes, right? That's coercive. That's not consent. So I think we do need to articulate in some way that we're there to care for them primarily, no matter what, has nothing to do with whether they say yes or no to law enforcement. On the opposite side is a patient who's refusing, sort of outright refusing, to provide a sample for a blood alcohol level. And I think in that case, we're not in the business of tying people down and restraining them for getting forensic evidence, right? That's not what we do, and I think generally speaking, we shouldn't do that in this case. If the police come back with a legal document, I'll say a warrant, the language varies, but even in that case, I think we still are not going to tie a patient down and forcibly take blood from them. Even in the presence of a warrant, from our perspective, they really need to assent, right? It's not consent, because at that point there's a document compelling them to do it, but they do have to assent. The middle ground, I think, is probably the area where, depending on your local institution and your local laws, you really need to think through, and that is when a patient doesn't have the capacity to say yes or no. So take, for simplicity, an unconscious patient. I think generally there's a presumption against taking blood from someone who's unconscious. They can't, say yes. They can't say no. The exception is, so for example, in New York, when people get their driver's license, they agree to drug and alcohol testing at the request of police. So at that point, it's not exactly implied consent, but there's a little bit of a presumption that maybe in the setting of a motor vehicleist, that we probably should get that sample. And so it may be something that we do, although we wouldn't turn it over to police without, a court order. And the grounds there would be that, the patient can't say yes, nor can they say no, right? I say it's not exactly implied consent, because although it's sort of written like that, the law has penalties if the patient says no. So if someone gets pulled over and out in the world, the police officer says, I would like to, breathalyze you, and they say no, they can do that. There's a penalty, right, involving maybe, jail time or their license or something. But that exists. So I think that those are some of the basic things that you need to think through. Same principles apply for sort of other samples. Someone who has drugs in a or suspected drugs in a body cavity, I think follow the same, as well as people's property. So I would just sort of end with the fact that thinking through a case like this, you really want to get it written down on paper in a policy for your institution, because the last thing you want is at 2 o'clock in the morning someone to call somebody, some administrator, who gives a varied answer based on their own knowledge or biases on this issue. Because probably most important is that we treat like cases the same, and they're not handled differently depending on who answers the question. And then, I think the policy should also articulate what has been said, which is you limit where possible, the amount of information that's given to law enforcement, and probably also have a designated liaison who's interacting with law enforcement. Because, I think as Quincy said, if every single member of the care team is interacting with them, it's much harder to follow a clear standard.
Taking the example of the intoxicated, agitated patient, as the physician, I want blood on that guy. He's got a deformed femur and an open ankle fracture. He may need transfusions. I want to know what his chemistries look like. I need to know his blood count. I want IVs. He may need to have contrast. I
Yeah, all important points, and I agree completely. I think the key distinction there for the first part is a blood draw that you're doing for clinical care versus one that you're doing, at the request of law enforcement for only those purposes. And so if you're drawing it for clinical care, as we often do in trauma, you do that thing, and it's in the lab, and if they want to, get that sample later, fine, right? They do it through the proper proceedings. There's a distinction there, and sort of what I articulated here is really just about if you were not otherwise going to do it for clinical care, whether you would do it for this purpose.
There's also a chain of custody piece that goes into play for that as well, right? So like what we draw for clinical care isn't necessarily what they end up using for evidence as well. So there's definitely complexity to that. I do, if it's possible, would like to have the questions go to the poll everywhere just so I can give the panelists more time to speak. I think the one thing that I'm hoping Debbie can help us understand is sort of the issues around getting that written request and sort of the interplay of how that's something that may be different potentially where we are, and sort of help us understand that piece.
So this again is something that varies quite a bit state to state in terms of how to get a warrant, how long it takes. It used to take much longer. Usually, so this issue of getting back to what exigent circumstances are. As you know, criminal law allows the seizure of evidence without a warrant if there are exigent circumstances, like imminent harm to a victim, destruction of evidence, flight of a suspect, those kinds of things. That doesn't happen often in the context of the emergency room where there are exigent circumstances. There was a finding of exigent circumstances in the Supreme Court case, Mitchell v. Wisconsin, where they did establish this implied consent doctrine where it's a patient who's unconscious, generally you can draw blood without a warrant in the motor vehicle context only. So it's narrow, but virtually every state in the country now has an implied consent rule with regard to motor vehicle accidents. So that's across the board. But pretty much now, law enforcement can get, and you guys can speak to this, but can get a warrant or subpoena very quickly so that the dissipation of the toxicity of the blood is not really an issue and it's not an exigent circumstance, so that you can wait for that warrant or subpoena before you actually draw the blood, particularly if you're not drawing blood in any event.
Yeah, exigent circumstances really now doesn't come into play, and there's also rulings for the U.S. Supreme Court, McNeely versus Missouri, where if exigent circumstances do exist, we have to be clear and specific in articulating why we need that evidence now. But by virtue of the fact of electronics, we're easily able to obtain search warrants quickly. There's no delay where at one time they were telephonic and you were trying to locate, if it was particularly after hours, calling the DA's, district attorney's office and trying to locate a judge. But those barriers have been removed. So for the vast majority, at least in the state of California, and again, things can vary from state to state or different law enforcement agencies, but we can easily obtain an electronic search warrant. So
I just want to add to that the warrant should be specific to the information that they want, and you're only required to give that information. And the general standard on release of information, the legal standard is minimum necessary. So you don't need to give more than what's asked, but only specifically what's in the warrant or court order.
So I want to ask one more question about this case, and there's really sort of two pieces to it. So the first is, what are your thoughts on how best to handle law enforcement presence in general in the ED? Because I think there's a mindset of, do they just come in and do what they need to do, or is there a way for us to, maybe insert a liaison, sort of as Julian mentioned, and that can help advocate and sort of navigate that issue with the patient? And then, should they almost like check in as a visitor, right? And I'm hoping that maybe Natasha, Cindy, and Greg can tell us. And then we do have one additional question about body cameras after this from the audience. We'll go to that next.
I think as ED providers, we have to maintain a culture of providing trauma-informed care for all of our patients, and one of those components is safety and stability. So as has been mentioned already, creating that letting the patient know that their care team is separate from law enforcement that might be on site, and if it needs to be a physical barrier or physical space between law enforcement and that patient, then it might be within our best interest to create a designated waiting area in our ED where law enforcement can wait in the initial stabilization of the patient. It can't, if you have an area with multiple trauma bays, it can be in that trauma bay so they can maintain line of sight if necessary, but still far enough away from the patient that they're not interfering with care. And in my experience, I've had law enforcement, again, like it's been mentioned before, follow us to CT with the patient. And when there are multiple people involved with the patient, I've sometimes broken away to guide the law enforcement to that waiting area and say that we'll be happy to answer any questions once we've stabilized the patient, and they can talk to the patient again once we've stabilized the patient. So I think that's an important distinction to make for us.
In regards to dealing with law enforcement, I think they've mentioned it a few times, but to wrap it into something that's easy to understand and remember, you have to pre-plan. When you wing something, it really doesn't always work out for the best if you're just winging it. So ahead of time, you need to take the time to get to know the officers that come into your facility, whether that be through their leadership and hospital leadership. Invite the officers for like a brunch or a coffee. We do coffee with the cop with the community a lot. You could do that with doctors and officers there at your hospital so they can get to know each other. Know the policies that your hospital has and know the state laws that are available in your state, so you know ahead of time. If you know that there's a policy, then you'll have more confidence when you deal with the law enforcement officer, because you're not winging it. And yesterday a different doctor told them something different that they could do, or a different nurse told them something different. It's very dynamic when you guys are trying to save a life, especially one example I could think of is if an officer is injured, there'll be 100 police officers trying to stand in the emergency room and be in the way. If you have a liaison that can direct them to a particular room, have that liaison deal with the supervisor of the officer and not the officers. We tend to be a little demanding, a little arrogant. We don't always listen the best that we could, but they do listen to their supervisors. Supervisors tend to be more mature and older, so you can have the supervisor wrangle them out to the designated room that you have. The importance of having a liaison, they're not involved with the actual incident as much, so their adrenaline is less, and when your adrenaline is less, you tend to think more clear. So they'll be able to work with the officers to get what they want. Real quick, with the McNeely versus Missouri, I saw someone's eyes pop up when they heard about the warrant. There was a case where they drew blood, and he challenged the blood draw, and the judge agreed with him because the blood alcohol content dissipates at a known rate, which takes away a lot of the exigency, because we know the rate that it's going to go away. If we know when they were drinking, we'll know at this time, well, when he was driving, it was this. So that's where that warrant originated. On my agency, we get a McNeely warrant for almost every time we want blood, just so there's no confusion. Generally, people do consent, but we always get the warrant anyways. It also helps with the case and if there's any appeals or anything like that. But I think it's important to just pre-plan and know what you're going to do ahead of time when you're dealing with law enforcement.
Okay, thank you. So I want to go to the audience question, which says, can you talk about policy and law around body cameras? When can we ask law enforcement to turn them off? And what are the allowances around having to testify about HIPAA or evidence that is recorded? Don't all jump at it.
Body cams are relatively new in law enforcement. Just over the past few years, some agencies require you to turn your body cam on as soon as you start your shift and leave it on for the entire shift. My agency, you only have to turn it on when you're dealing with a member of the public. If you're in your car, you don't have to have it on. Have a policy set ahead of time for body cam. You can ask them to cover it or turn it off, or don't speak about the medical issues that We do use it and leave it on when we're dealing with the in custody person, when we're transporting a suspect back and forth, it will be on. There's no problem to ask an officer to wait, like we talked about in the other room, or where they have visual contact. Just don't speak about hit-related stuff right in front of them. And deal with their supervisor if they start to have a conflict with you. There's no reason to argue and fight in front of patients, and that distracts you from the patient care.
If I can dovetail off of that, like Greg said, body cameras are new in law enforcement, and there's some agencies that still have not received them, and this is something that's ongoing and we're developing. So your hospital, whoever your point person is with your hospital, if this is a concern, really to front load and contact that agency, those agencies, and start working together collaboratively to develop what your plan is or developing policy within the hospital. So that it's not something while you're in the middle, in the thick of things, that it has to be dealt with. So front loading, planning, preparation with your leadership, and then again, having that point person in your ED who may have to deal with that law enforcement officer. And always, when in doubt, whoever your point person is, to contact the supervisor of that law enforcement agency who's on duty at that time, if there's any difficulties. Something you shouldn't be dealing with, but somebody that's pre-designated in your ED perhaps can deal with.
And when you, as you mentioned, when you design your policy, make sure the local agencies have that policy. Make sure they know what it is before they get there, and that they brief that beforehand, so there's no conflict at the time that'll interfere with the care you're giving. Put signs up at the entrances to the emergency room regarding your policy, what the policy is, body cam wise, so the officers know ahead of time what's happening, what the plan is.
We haven't dealt with this issue very much in New York yet. I'm sure it's coming, but we do have a pretty clear policy on audio and videotaping generally, and it's not permitted without staff or patient agreement. And I mean, it's obvious to say this, but one of the concerns about the camcorder is that they're not only capturing the patient of interest, but other patients and other staff who may not want to be recorded or videotaped. So it's a complicated area.
Any other thoughts from the panelists? I realize that we have 5 minutes left, and this is easily a day's worth of information to unpack. So just for you guys to help us choose what we talk about next. So we could talk about contraband. We could talk about de-escalation and how best to do that with and without law enforcement if they're around. Or we could just kind of leave it to audience questions. So you throw them into the poll everywhere. I can kind of talk about it. So any particular burning things that interest you at the moment, I can easily make them talk all day, so I can do that. Okay. Yes.
I would really love to talk about contraband. I'm really interested in the question of basically to what extent contraband can remain the property of the patient upon their departure, even if it is a sort of a so-called illegal substance. I think that the question that's come up with us is that particularly our security team in the hospital will tend to presume that something like drugs or even alcohol should be thrown out and discarded. And at face value, that seems to make sense to me. And at a secondary level, it makes no sense to me because certainly that alcohol is their property, they bought it, and it's legal. And frankly, increasingly, that marijuana they may have on them is also legal. And that substance that they have on them that none of us have tested and aren't forensic experts about, we're just guessing is illegal, as far as I can tell. It seems to still be theirs. So I should know how people would approach that.
Well, one of the things that we dealt with within our hospitals is, first of all, what's your hospital policy on what is illegal contraband or not admissible contraband in the hospital? For example, one of our hospitals, no scissors, no pocket knives, things that could be perceived as a weapon, not permitted in the hospital. But if that individual's out in a public area, it's perfectly legal to have. So having your policy, hospital policy,
and give them the contraband on back when they were outside the facility. That way they didn't have it when they were, going back to the ED as they were leaving or to the hospital. So security would escort them, give their property back, which contained the pocket knife or scissors or whatever it was that was contraband. The found narcotics worked well for us because it didn't jeopardize the trust between the medical staff and the patient, and they were working from home, and then we have a conversation. But that also gets the hospital sued and, puts them in less risk, even though.
Unfortunately, I've also seen found contraband end up in the pockets of staff or police officers. Is there a way that I can make certain that this becomes bagged and maybe not lost on the way to the precinct house?
So we also had that happen. Usually more often it was with, they were claiming that money was missing more than the types of contraband. If your hospital has set policies, those policies have to have teeth to them for your staff. So if someone reports that something's taken or missing, you can refer to the policy and the investigatory process that the hospital will go through to find out if that actually happened, and then there'd have to be discipline that goes with that. For law enforcement, anytime there's an allegation of misconduct, there's an investigation that's completed, but you would just have to initiate that, hey, this guy said that he had this out, and now it's missing, and your officer was the last one that had it, and then there would be an investigation on our end as to where that went and what happened.
So we do have one other audience question, and I think we can maybe do some closing thoughts because we are at time soon. If the officer steps out of line of sight, but can still hear the things I may need to know about my patient to guide medical management, is that considered a confession if they are overheard? Things like body packing, stuffing, ingestion of narcotics, asking about injuries of an altercation or assault. Yeah, basically, the point of the question is like if the officer isn't fully out of earshot and they hear something that is said between the physician and the patient in regards to things like, body packing, for example, that was brought up, is that something that the officer can use against the patient later?
If the officer hears something spoken and he's standing where he's legally allowed to be, anything that he hears would be admissible. So you may want to move him a little farther away.
Right. Okay. So, I think the other thing that we didn't really talk about was sort of de-escalation and how best to do that. So I just want to give a quick sort of thought on that because I think that is a potential area where things go wrong with escalating behavior. And so, I think the main thing to consider in that situation is to, one, as clinicians, know your surroundings and how to be safe and do de-escalation training. And I know Greg and Cindy have done a lot of that for the clinicians at Herbie UCLA. And I think that is a really key component to kind of be knowledgeable and not trapping yourself, and then using the least amount of force and medications that are necessary. I kind of want to summarize a lot of the important nuggets of information that you guys talked about, and I think that the one thing that I'm hoping at the very least that you guys can learn from this is how to take back some of these concepts into your everyday practice, right? How do we, interact in a more knowledgeable fashion and sort of navigate all these different complexities that are affecting the patient? And then I think the key thing that everybody here talked about was the need for hospital policy and an interdisciplinary one, right? We cannot make this alone in our silo and think it's going to be effective. So we need to get everyone at the table, whether it's the clinical departments of nursing physicians, hospital leadership, patient advocates, community members, hospital public safety officials, your legal and risk management, all the leaders and law enforcement and everything. We need to come together at the table to be on the same page, right? And then once that policy is created, making sure that there's an emphasis on patient care and privacy, and then sort of defining the role of these public safety personnel in our spaces. And I think clear guidelines is something we all sort of sorely need in the moment. And so how do law enforcement have access to the patient, their belongings, or their personal information, right? And the policy, it would be helpful to identify, if staffing allows, to have this sort of primary liaison that's like not clinical to help interface with the patient and law enforcement. And then, really having some sort of on-call resource after hours. That's when everything goes down, is after hours. And so, having someone like Debbie be on call that we can ask, what are we supposed to do, is a really sort of helpful way to navigate the problem. And then once you operationalize a policy like this, how do we actually audit its compliance, right? So great first step in getting something in writing, but like, how do you know it's actually being done in the moment? And then, I think that there's a bigger conversation to be had nationally amongst our societal academies, everything, and even for sort of the accreditation agencies for trauma centers, right? This is something that we interface with trauma all the time. And so there's room for us to do this on a bigger stage. And I'm very happy that you guys were able to attend and we were able to get everyone at the same table. But we need to do this on a bigger level because it affects all of our patients. I think we're probably out of time, but I don't see another Bernie didactic coming in here. So while we have the space, if there are other questions, you want to pick their brains. Yes.
You had mentioned before about patients reporting in the emergency department. It's something we're faced with on a routine basis. We have policies that are put on the wall, which is do not record. But I've yet to be able to figure out what you do when someone actually does. And I've seen places where people try to erase it, but sometimes patients refuse. And there's a level of how much you can escalate. What are the realistic options you have? And patients, nowadays there's increasing people with their cell phones, supporting doctors, taking pictures, and clearly getting people that don't want to do that. So what are the realistic options or methods if the patient says, it's my right, I'm going to do it? I'm not, I see the policy, but I'm still going to go ahead and do that.
So you're right, there are not a lot of good answers, and this is increasingly an issue. As I had mentioned, we have a policy where you have to get permission to report, but now we're sort of at the point where we're telling all staff, assume that you're being recorded. You should always ask that you not be recorded because of that assumption. Some people will listen, others won't. When we know that someone's being recorded, we will ask them to erase it, but of course they don't have to. We don't know if they do. And we don't confiscate phones or anything. But it's an increasingly complicated area. There are not a lot of good options except to assume you're being taped.
Yes, we'll take this last question. Yes.
So do you have some advice, and this may be over answer about how or whether we should counsel patients who are being questioned by law enforcement after they've been medicated? This is they're not in hospital, they're stable, we've medicated them with some pain medicine or maybe benzodiazepine, and now they're being questioned by law enforcement. And maybe the judgment is impaired as a result of our medication.
Well, I can respond from a law enforcement perspective, then they have a great defense later on saying that what they said was they were under the influence of medication, and that more than likely will be thrown out and not used, those statements.
Yeah, you should, I would recommend counseling the law enforcement before they question him. He's medicated, he's not prepared to be questioned, he has to come back. Anytime I would question somebody, I would make sure that they hadn't already been medicated. Because it's gonna get thrown out, it's a waste of my time to get those statements that aren't gonna be done later. So I would talk to the law enforcement and let them know that the patient's medicated, he's not in his right mind, so no, you don't need to do it.
I also, as a general rule, would just tell patients, regardless of the medication question, I'll tell patients, you're welcome to talk to law enforcement if you want to, but from our perspective, we're going to give you the best medical care we can, regardless of whether you, cooperate with your investigation or not. We're not going to share it. Make sure that they understand that there's a separation.
I think medically it goes back to whether or not the patient can even consent, Like, are they of the right sound mind to be able to give consent to have that conversation yet? Yeah. Okay, thank you, everybody. Appreciate your time.